Hello students, welcome to Ashish Pulala classes. Today in the present video, I am going to discuss with you section number 19 of CPC. This section number 19 of CPC clarifies to us that what will be the place of institution of a civil suit in case the wrong is alleged to be done by the defendant either as to the person of the plaintiff or to the movable property of the plaintiff, and the plaintiff intend to take compensation for that wrong from the defendant. Basically, section number 19 deals with a situation wherein the cause of action arises at one place and the defendant either resides or carries some business or personally work for gain at another place. That means to say, when the cause of action and the place of residence or business of defendant are different, then the provision of section number 19 will have to be used. I want to repeat this para. Section number 19 deals with a situation wherein the cause of action arises at one place and the defendant resides or carries on business or personally work for gain at another place. We all know that the cause of action arises at the place where the wrong is done by the defendant. Section 19 of CPC provides that in such cases where the cause of action and place of residence of defendant are different, then in such cases, two courts shall be competent to entertain and try the suit for compensation. And what are those courts? First of all, the court within whose local limits of jurisdiction the wrong is done by the defendant. And the another court is the court within whose local limits of jurisdiction either the defendant resides or he carries on his business or he personally works for him. In this way, this section grants option to the plaintiff that he can move any of these two courts which having the jurisdiction to entertain and try the suit against the defendant. What is stated in section number 19 of CPC? Let us study. According to section number 19 of CPC, where a suit is for compensation, and this compensation suit is for wrong done to the person or to the movable property. If the wrong was done within the jurisdiction of one court, and on the other hand, the defendant resides or carries on business or personally works for gain within the jurisdiction of another court. That means courts are different. Wrong was done within the jurisdiction of one court, whereas the defendant resides or carries on business or personally work for gain within the jurisdiction of another court. Then the suit for compensation may be instituted at the option of the plaintiff. Plaintiff has the option that he can institute the suit in either of the said courts. That means to say, he can institute the suit where the wrong was done, or he can institute the suit where the defendant either resides or carries on business or personally work for gain. Let us understand section number 19 with the help of some illustrations. There are two illustrations of section number 19 which are attached in the Bare Act. In the first illustration, A residing in Delhi, that means to say A is the resident of Delhi. He beats B in Calcutta. It means to say the cause of action arises at Calcutta. So in future, If B wants to sue A for compensation for wrong done to his person, then B may sue A either in Calcutta, where the defendant A is residing, where the cause of action has arisen, or in Delhi, where A is residing. That means to say he can sue A either in Calcutta or in Delhi. In second illustration, A is the resident of Delhi. He published in Calcutta statement defamatory of B. It means cause of action arisen at Calcutta, where the defamatory statement had been published by A. In this case, A is the defendant and B is the plaintiff. B may sue A either in Calcutta or in Delhi for getting the compensation for defamation. Okay. There are two words which are employed in section number 19. The first word is wrong and the second word is movable property. What is the meaning of the word wrong? The word wrong, which is employed in this section number 19, refers to the actionable wrong for which action can be taken by the plaintiff. Basically, it is a tort, it is a civil wrong, or it is the infringement of legal rights of the plaintiff. But it is very important to note that this section number 19 does not apply to all types of actionable wrongs. Where it applies only to those actionable wrongs that affect either the person or movable property. If any wrong is committed to the immovable property, by committing the wrong of trespass to the immovable property, or nuisance to immovable property, or infringement of easement right, then the same will fall under section number 16, clause number E, and it will not be covered by section number 19 of the code. Okay, so this is something about wrong. The another word which has been employed in section number 19 is the movable property. That means to say, when the wrong is done to movable property. That means to say, what is the meaning of wrong to movable property? Section number 19 applies to a civil suit where a wrong has been done to the movable property, and due to this wrong, value of the movable property has diminished, and the plaintiff claims compensation for the damage caused to his movable property. Okay, so when we combine the word wrong and movable property, due to the wrong of the defendant, there must be loss to the movable property in its value. But where the movable property, that means to say ornament, has been merely taken away, not any wrong has been committed to the movable property, and after taking away the movable property by the defendant detained that movable property. Then to get back that movable property or ornaments, section number 19 does not apply. The suit for its return would be governed by section number 20, clause number C. We will discuss about section number 20, clause number C in the next video. For the time being, let us fix on section number 19. Why this suit was not instituted in section number 19? The reason is very clear from the bare language of section number 19. That section number 19 has no application to a suit for compensation for wrongful detention of movable property, because it do not diminish the value of the movable property. But section number 19 applies to suits which are based on diminution of the value of movable property due to the wrong done to the movable property. Now the another point which has been arisen, that whether section number 19 can be applied in case the suit is to be filed against the government, for which two words are necessary to be read out. The first word is resides. The word reside refers only to the natural person, but government is not the natural person, it is the artificial person created by the law. The another word carries on business. It refers to the commercial business, but we know the government is not doing its commercial business. Government is always doing the business for the public welfare. So therefore, section number 19 does not apply to the suit against the government to get the damages for a tort committed by the government against the plaintiff. Then how the civil suit has to be filed against the government? Then the suit against the government for getting the damages lies in the court where the tort is committed. It has been held in the Golak Das Belaram versus Baldev Das case. Some more important which keep to be mind in reference to section number 19, these are: sometimes we know that the wrong done to the person or movable property may not be confined to a single act. That means to say, the wrong is not done by a single act. The wrong involves a series of acts, and it may not be possible to specifically state that what was the place where such wrong was committed. So what will happen in that time, as it is not possible to tell the place where the wrong was committed? So in such an event, for filing the civil suit to get the compensation, the suit has to be filed before the court within whose local limits of jurisdiction either the wrongdoer resides, or he carries on business, or he personally works for gain. It may also happen that a wrongful act is done at one place, but the resultant damages due to that wrongful act is caused at another place. In this case also, it is open to the plaintiff that he can institute a suit either at the place where the wrongful act is done, or at the place where the resultant damages is caused. One more option is open to the plaintiff, that he can file the civil suit before the court where the wrongful act was done, or where the resultant damages is caused. If, for example, if A has committed a wrongful done with B at Kapurthala, whereas the resultant damages caused at Jalandhar, then the plaintiff can file a civil suit either in Kapurthala or in Jalandhar, or he can definitely file the civil suit against the defendant where the defendant carries on business or personally work for gain, or where he resides. So this is something about section number 19 of CPC. If you like my channel, then please subscribe my channel. To get the notes of this video, kindly go to the description box and click on the link which is provided in that description. Thank you very much.